Filing of annual returns for companies in Nigeria. Annual return is a mandatory requirement or obligation that every company, enterprise, business name, and incorporated trustee in Nigeria must fulfill once every year to the Corporate Affairs Commission in order to appraise the commission that the company is still active and in operation. It requires submitting the updated information annually regarding the operations of your company, the structure, and compliance with rules set down by the Corporate Affairs Commission. This is done to maintain good standing and transparency with the Commission. A company is expected to file its annual return not later than 42 days after the company's annual general meeting. Companies in their first year of incorporation are expected to wait until after 18 months from the date of incorporation to file its annual return. This is very important, particularly for companies duly registered either as a private limited company, a public limited company, companies limited by shares or by guarantee, an unlimited liability company, and NGOs. The essence or importance of filing annual returns are: firstly, it maintains accountability and transparency. Accountability and transparency are guaranteed when the company maintains accurate record with the Corporate Affairs Commission. The company demonstrates its dedication to legal and regulatory compliance by providing correct and up-to-date information on a regular basis. This transparency fosters trust and demonstrates that the company has nothing to hide, as other businesses and regulatory authorities may rely on the company's compliance and openness, resulting in a more stable and trustworthy business climate. Also, it provides the company with the opportunity to update any change made within the company's structure, directors, or shareholders with the commission. Also, it avoids financial consequences which may lead to loss. There are penalties provided by the Commission in the case of late filing. It serves as a means of informing the Corporate Affairs Commission that the company is still active and in operation, which helps the company, business name, or incorporated trustee remain on the CAC register. There are consequences set out by the Corporate Affairs Commission for non-compliance with filing of annual returns, which are as follows. First, it can lead to delisting and striking of company name from the register. Prior to removing a company from the register, the Commission will issue a notice of intention to strike off names of companies it reasonably believe are not conducting businesses or are otherwise dormant due to failure to file returns for the period of 10 years. Companies will be given additional 90 days to file the required annual returns and send an activation email to the email availably provided by the CAC. Companies that fail to comply with the requirements will have their names removed from the register. Once a company is struck off from the register, it is considered dissolved from the date of publication. It will then be illegal to engage in any transactions or dealings with a company no longer in existence. Also, if a company fails to file its annual returns, both the company, its directors or officers may be subject to penalties as prescribed by the Commission. It is pertinent to state that, in a case of late filing, the Commission set out a list of amounts to be paid, which includes late filing of annual returns for companies results to a fee of 5,000 naira per year. Late filing of annual returns for private companies other than small companies will result to a fee of 10,000 naira per year. Late filing of annual returns for public companies will result to a fee of 25,000 naira per year. Late filing of annual returns for business name will result to a fee of 5,000 naira per year. Late filing of annual returns for companies limited by shares and companies limited by guarantees will result to a fee of 10,000 naira per year. Late filing of annual returns for limited liability companies will result to a fee of 10,000 naira per year. Also, you will be required to pay an agency charge to the accredited agent in addition to the expenses mentioned above. It is important to state that the law provides the following as requirements for the filing of annual returns, which are: in the case of companies or a company, these are the requirements: company registration number, company name in full, Annual return made up to the date after the general meeting for that year. Date of general meeting. Company's business classification for principal activity. A brief description of the company. Company type, the registered office address, head office location if different from the registered office address, officers of the companies, the directors, the corporate secretaries, and their details, which are their full names, phone numbers, address, local government, nationality, email, country stroke state of residence, title, and date of birth. The statement of issued share capital, statement of capital, particulars of indebtedness, list of past and present members, certifications and other documents accompanying annual returns, which are a written copy certified both by a director and by the secretary of the company to be a certified true copy of every balance sheet and profit and loss account laid before the company in general meeting during their period of which this return relates. The particulars of turnovers and net assets. A form containing the details of persons with significant control. List of the person or name of the person filing the return. In the case of business name, these are the requirements for filing annual returns. The business name details, which is the registration number, the business name in full, the general nature of the business, the principal place of business, which is the building name, building number, streets, city, local government, and postal code, brand address, if any, the annual return details, the building name and number, particular stroke details of corporate partners, if any, financial statement of the year, name of person filing the return. If in the case of incorporated trustee, these are the requirements: name of association, registration number and classification, registered office address, which is the building name, number, streets, city, local government, and postal code. Annual return details, the particulars stroke details of corporate partners, if any, the financial statement of the year, name of person filing the annual returns, the impact of being struck off from the company's register. Com- These are the impacts of being struck off from the Commission's register. It may lead to loss of legal standing and inability to conduct business legally in Nigeria. When a company is delisted, the CAC no longer considers it as a registered company, and it is no longer permitted to undertake any form of transaction or association in Nigeria. This means that the business has lost its authority to operate as a registered company and is prohibited to participate in any transaction or deal with a company that is no longer in existence. It could lead to the loss of relationship with customers, suppliers, and other business partners. On the 31st of July 2023, the Corporate Affairs Commission made an announcement for the delisting of inactive companies. This process was launched as part of an ongoing effort to delist 100,000 companies for failing to file annual returns and comply with the stipulated laws. This was followed by a public notification on August 2nd, 2023, and updated in December 2023 regarding the reduced list to 91,843 companies scheduled for delisting. When a company gets delisted or loses its legal status, its credibility and trustworthiness among customers, suppliers, and other business partners suffers significantly. Customers may be hesitant to work with a delisted company due to concerns about stability and capacity to meet up with agreements. Suppliers may withdraw services or demand tighter payment terms in event that the company fails to meet its obligation, and other partners may avoid collaboration with a company that lacks legal recognition due to reputational or financial risk. In effect, The company's incapacity to operate properly and reassure stakeholders of its survival may jeopardize these important relationships and limit commercial operations. For a private company, shareholders may find it difficult to sell or transfer their shares. If the corporation is unable to operate legally, its shares may become non transferable or sellable. Shareholders may also lose their right to receive dividend or financial benefits from the company. There are procedures or reliefs available to affected companies as provided by the Commission. Any person aggrieved by the striking off of the name of their company from the register may apply to the courts at any time before the expiration of 2 years from the date of striking off. If the court is satisfied that it is just to restore it to the register, the court may order the name of the company to be restored. Or any person aggrieved by the striking off of the name from the company register may write an official application letter to the CHT Registrars General stating why the annual returns were not filed on time. In addition, the application, all payable dues and updated company records must be submitted. If the application is approved, the company will be awarded a relisting certificate. Note: if your application to the court is successful,